thank you for coming. This is the personal liability session, what you as compliance officers need to know about this kind of very important topic of personal liability, and one that is evolving. I think there's no way that you can underestimate how much this is front and center for each of you. Just last week, Thomas Curry testified before the Senate that in the wake of the Wells Fargo investigations that he was going to hold people personally responsible at Wells, and who knows where else. I know that we know that there's lots of ongoing queries about this kind of account opening and what was charged. So there's that very much to think about. And then in addition, those of you who are either regulated by the New York State Department of Financial Services, or who know someone who is, or are aware that New York State Department of Financial Services, what they do may have implications. Last week they introduced another accreditation, this one around making your firm sign on that it has all the proper cybersecurity procedures in place, appoint a chief security intelligence chief, well, someone can correct it, officer, and then again, like certifying the AML program, that's going to have to be signed by somebody, or we were just talking, or the board has to approve a resolution. So there's going to be people taking that real responsibility in front of the New York State Department of Financial Services. So I think we have a really good panel to look at this topic. And I'm going to do a brief introduction, and they'll have to forgive me if I've forgotten some important detail about their lives. Any of the Nobel Prizes or anything that someone has won may not be mentioned. And then we're going to go right into our presentation. So sitting on my right, and I'm going to introduce people in the order in which they're going to speak, is Sharon Cohn-Levin, who is a partner at William Hale in New York City. She is a leading authority on anti-money laundering, Bank Secrecy Act, economic sanctions, and asset forfeiture. She served for 19 years as the chief of money laundering and asset forfeiture in the U.S. Attorney's Office for the Southern District of New York. And while there, she prosecuted and supervised many of the Department of Justice's most complex and significant money laundering cases, BNP Paribas, Lebanese Canadian Bank. Sharon has also worked closely throughout her career with state and federal banking regulators, U.S. Treasury's Department of Foreign Asset Control, Office of Foreign Asset Control, FinCEN, and the Department of Justice, of course. Next to her is Polly Greenberg, who is a managing director on the regulatory consulting team at Duff & Phelps, focusing on areas of financial crime, including money laundering, anti-bribery, corruption, sanctions. And prior to joining Duff, she spent a total of 14 years with the District Attorney of New York, time interrupted by 3 years in the private sector, private practice. And she served as a assistant district attorney while at the District Attorney of New York, and had a number of senior supervisory roles. John Sabatini is a principal at PwC with more than 20 years of financial services and technology control experience. And prior to joining PwC, John served as the head of technology audit for a global investment bank, where he had a 60-member technology audit team. He also previously worked as a principal at a large professional services firm where he led the compliance technology enablement group for the New York Financial Services Office. Finally, and this is a surprise guest, William Langford. We really felt like we needed somebody from the industry to beat up, and none of you volunteered. So William has agreed to step in as the practitioner. And he is, of course, although many of you know him, Chief of Compliance at GE Capital, responsible for the firm's compliance program. Before joining GE, he was Global Head of Compliance, Architecture and Strategy at Citigroup, where he was responsible for, obviously, compliance, risk analytics, and assessments. He also has, as we all know, a stint with JPMC, and he served as Associate Director for the Regulatory Policy and Programs Division of the Financial Crimes Enforcement Network. We hope to have some time for questions. I'll have some questions, but Sharon, why don't you get started?
Sure. Thank you so much for having me here. I am thrilled to be on this panel, and I'm very happy to be talking about a topic that, at least if I were a compliance officer, I would be concerned about, which is your personal liability. So there you are. That's me, Sharon Cohen-Levin. Okay. So this has been, I mean, this year in general has been a big one in terms of holding compliance officers liable, or warnings that compliance officers are going to have to be liable for mistakes in their institution. And in particular, an area that's been under increasing focus is the AML compliance officer. And in particular, issues with whether or not there are mistakes in an AML program. In particular, almost all regulators and the Bank Secrecy Act requires a financial institution, to have an effective anti-money laundering program and to file SARs. And typically in an institution, the person that oversees that process is going to be the AML compliance officer. And when mistakes are made or programs are found to be deficient, unfortunately, regulators are increasingly looking at the AML officer to try and hold them responsible. And it shouldn't be a surprise. I mean, if you look at sort of what you're hearing from the Department of Justice, from the Department of Treasury, from the government in general, there's a real focus right now on the idea is corporations don't commit crimes, individuals commit crimes, and you have to find individuals that are responsible. And you're seeing this from all throughout the regulatory and, frankly, the law enforcement spectrum. I have here a couple of sort of cases that have come up this year that are in that space. Probably the most significant one coming from FINRA is the Raymond James case. It's also the most recent. Essentially, FINRA found that Raymond James had failed to have effective anti-money laundering programs. Specifically, they found that they didn't have an effective program. That program wasn't targeted to the risk of the institution. What happened with Raymond James is that the company, the firm grew over time. And the AML practice didn't take into account that risk and that change in business and that expansion. And in particular, FINRA focused on the fact that there weren't sufficient resources, that there wasn't a single written procedures manual, that there were deficiencies in SAR reporting, and that they missed significant things. But what was somewhat shocking about it, I mean, it was a significant AML failure, and at the end, Raymond James was fined $17 million for those failures, and it was the largest one in FINRA's history for an AML violation. But what was, I thought, somewhat surprising is that the individual AML compliance officer, she was fined $25,000, and she was suspended for 3 months from the securities industry. And even though these sounded like major institutional failures, inadequate funding, a program that was out of step with the practices of the firm, FINRA sought to hold the individual responsible.
And Sharon, that money is going to come out of her pocket then, do we think? Or what does this work? How does this usually work in a firm?
It's not clear. It depends upon, in general, in terms of fines. For FINRA, they do not have a specific prohibition preventing the company from paying. However, it depends upon essentially Raymond James's sort of, structured. Do they have an indemnification policy? And oftentimes it depends upon what's required under state law. Some of the regulators, FINRA isn't one of them, but some of the regulators actually prohibit the company from paying off the penalty of the officer. And in fact, if you look at the next case on their Gibraltar Private Bank and Trust, in that case, the OCC assessed a penalty against the chief compliance officer. It was only $2,500, but they specifically required that the individual pay it himself. They would not allow the company to pay. And similarly, other regulators have comparable policies. The other really significant thing in significant development in the personal liability for compliance officer space is the district court's decision in FinCEN and DO's action against Thomas Hayter. For those of you that don't recall, Thomas Hayter was had been the chief compliance officer for MoneyGram, and he was in charge of the AML, the anti-money laundering practice, as well as fraud detection. And ultimately, what happened was the Department of Justice brought a case against MoneyGram for aiding and abetting the fraud, as well as for having a defective a deficient AML program. And they entered into deferred prosecution and paid $100 million and have I believe it's a 5-year monitor. 2 years later, 2 years after the DPA was resolved, FinCEN and FinCEN assessed a penalty against Thomas Hayter, the chief compliance officer, for $1 million and brought an action with the U.S. Attorney's Office in the Southern District of New York to ban Thomas Hayter from the financial services industry for life. Mr. Hayter they transferred the case from New York to Minnesota, and he brought a motion to dismiss, among other things, arguing that the Bank Secrecy Act did not authorize suits against individuals. It was just against companies. And the decision came out from the district court in Minnesota, and the court held that yes, the Bank Secrecy Act does authorize suits against individuals. And so here, what has happened is that for a willful violation of the Bank Secrecy Act, FinCEN can assess a penalty and they can seek to ban a individual within the institution, for whatever period, seek an injunction enjoining them from practicing in that space. Obviously very, very significant. The case went forward. It was just a motion to dismiss. The case dismissed. The case is going to be in litigation. A couple of other sort of interesting features is most of these cases, like the FINRA actions that I'm talking about, the other ones that are up on the screen, they're brought through FINRA's process. They bring it as typically as a settlement, or it would be a proceeding before an arbitration panel. Here, this actually has to be brought by FinCEN and the Department of Justice as a civil action brought in court. The district court in Minnesota found that there was no deference to be given to the assessment found by FinCEN, that it's a de novo case, so we'll proceed like a civil action where FinCEN will have to prove its case and it will be fully litigated. But it sort of was a wake-up call, I think, to people in the compliance field that there is a mechanism, certainly for AML, to be found personally liable. And this is a big case. It's $1 million. It's a lifetime ban. And unlike institutions that oftentimes will reach settlements and not challenges, this is a case that I anticipate is going to go, quite far.
When you say quite far, you mean it's going to be a long trial, it's going to be appealed, it's going to be...
I think that it's not going to be settled. I think it'll be, who's to say what's going to happen, but an institution, for a whole host of reasons, when there's an allegation of an AML failure, an institution has every interest in trying to reach a resolution with its regulators, particularly if it's brought by the regulators, its own regulators. It's going to figure out a way to try and work out a resolution, because it just doesn't, most large institutions don't have the appetite to litigate this or the desire to litigate it. Here, it's an individual, it's a lot of money, it's $1 million, and it's a lifetime ban from his business field. So an individual is going to be in a position where they are going to challenge this. It's also going to provide a lot of guidance probably on the ins and outs of what is required to show whether or not there's an effective AML program, as well as what was also involved in this case is decisions not to file SARs. So I think in this case, while unfortunate for Mr. Hayter, for the AML area, it's going to provide a lot more guidance on sort of what is an effective AML program, what kind of information is relevant to filing SAR decisions.
Move on?
I'm turn it over to Polly to talk about some...
Hand her the...
hand her this, yes. Thank you.
We have the famous handoff.
Yes.
Hi, good afternoon. I too am very happy to be here to talk to you today a little bit about this really important topic for many of you. I want to talk a little bit about sort of some context that I think we can put this whole question of personal liability in. And I'm going to very briefly reference some new policies that have been somewhat recently announced, some more recently than others. I'm not going to go into a lot of detail because I think that'll be a topic of discussion for the panel. But as you all heard, I am currently working as a consultant with Duff & Phelps, and I focus on AML and other financial crime controls and investigations. Before that, I was a prosecutor for many years. My final position there, I was chief of the Major Economic Crimes Bureau at the Manhattan DA's office, where I supervised the last 6 economic sanctions cases against international financial institutions, one of them working very closely with Sharon on. And I bring that up because in those cases, most of them resolved with DPAs, one with a criminal plea. And I think that the DPAs, which were sort of the hot topic a few years ago, were sort of giving way to the issue of personal liability. And I think it's a natural progression because what DPAs really did, in part, was provide a mechanism through which it really became established that corporations could be liable for the activities that were conducted by individuals who were acting on behalf of the corporation. And while I think now that seems sort of almost like an obvious point, it really wasn't for a long time. I personally believe that a lot of those large cases without DPAs would not have been resolved on the large scale that they did, because that somehow having some sort of control over the process where there were really massive potential consequences allowed those cases to go forward and be investigated as fully as they were and resolve in such significant way. But now the attention is turning to the individuals who work for the corporations and who actually act. So in my view, I think part of this is motivated by the government's recognition that the public feels frustrated and impatient by what it perceives as deals which are given to corporations, but which ultimately get paid for by shareholders, and which don't necessarily have particular consequence to the individuals who act on behalf of the corporation. I think the policies are also an attempt to get corporations at the highest level involved, the tone from the top. And there are a few ways in which we are seeing this specifically in terms of policies. So first, the Yates Memo, something which probably most of you are familiar with. My slides are dense, but I'm going to refer to them all very briefly. The Yates Memo really follows up on the federal government's corporate charging memo, which, among many other things, very importantly says a corporation that cooperates fully will get cooperation credit, and the consequences, criminal consequences, will be less than they would without cooperation. The Yates Memo says, yes, that is true, but you get the cooperation credit only if, from the onset of the investigation, you investigate culpable individuals, see if there are culpable individuals, and you provide information found against those individuals to the government in a timely manner so that it can be acted upon while it's still fresh and actionable. That policy went into place about a year ago, and more recently, I know this is not an FCPA panel, but I think it's worth mentioning the FCPA pilot program because, again, it's just consistent with this government focus on what can be done in order to try to gather evidence to prove cases against individuals, which has been a struggle to do. And the FCPA pilot program, in the FCPA context, again builds on the corporate charging memo to say that corporations will receive vastly more lenient treatment if they cooperate, but again, only if that cooperation includes timely investigating and providing information against culpable individuals, employees, third parties, whatever they may be.
Let me ask something on the Yates Memo. and Polly, since you've got the floor, you go first, but if anybody else wants to add in on this too. There was on the surface, it appears as though you'd better bring forward the employees who you think in any way responsible, and perhaps someone might say cynically throw them under the bus. But are we seeing is there any change really that's happened? The Justice Department at the time that memo was released, William is nodding his head, he'll get him. At the time the memo was released, the Justice Department said, well, this is really, it's sort of a change, but at the same time, you're always supposed to have done this. What do we see? Is there a change in how justice is?
Well, I would generally agree that while it was always done that way, it also does represent a real change. These memos are not issued willy-nilly and very frequently, and when one comes out that says we are looking at individuals and you will not get cooperation credit as a corporation unless you do a timely, and that's really key, investigation and present the evidence, I think there is a difference. It's still early days. These investigations take a really long time, so I'm not sure that we've seen the results of them. But I think that there is a tension that's created between the corporation and its employees, and certainly in terms of representation and getting individual representation early on, that is something that is happening.
You want to add something?
Yeah, well, I was at the Department of Justice for a long time, and I will say this isn't really a sea change. This was always, the goal was to bring cases against individuals, not to resolve everything through corporate resolutions. And I think that most of what's in there was pretty clear to most people at the Department of Justice. But the difference is, number one, putting it in writing and putting a focus on it, it makes it clear that there's a clear understanding across all of the U.S. Attorney's offices and all of the Department of Justice that this is the policy. But second of all, it put procedures in place where they weren't before. And in particular, I've actually, now that I'm on the other side, I've been representing a couple of different companies that have been involved in internal investigation. And something that was never heard before, at any point when you're doing the internal investigation, there comes a point where it's time for your Yates presentation, where even if the corporation doesn't believe that individuals were really accountable, there comes a time when you have to present to the Department of Justice the individual's conduct and be able to disclose all of that. That was something that didn't happen in the past. And two, in terms of prosecutors, right now, prosecutors cannot resolve the case without taking into account individuals. So even if you have a nice resolution and there's no individuals, and an individual prosecutor is going to have to write a memo justifying why they're not going after individuals, and that puts it on a different level. It doesn't mean that there are going to be unfounded prosecutions of individuals, but it causes a real focus and attention on that, and that's something that I just wasn't there before.
Anyone want to add anything to that before you go back to?
I would just say I agree with everything that has been said, but Polly's point is probably worth repeating, which is you don't say it unless you mean it, right? And so I think if nothing else, at a much higher level, it really does contribute to the environment, right? And I think when talking to very smart people, much smarter than I, they say relax, that the number of people that they're going after and the circumstances are very different from day to day. But if you're worried about an environment that's fueled by people wanting to pick up pitchforks, forks, and torches and drag bodies through the street, things like this just sort of contribute to it, and I think it has an impact on behavior.
Sure. New York.
Okay. So moving on to New York. So New York's banking regulator, the DFS, has also gotten involved in the action here. And they recently issued a final AML rule. They had put out the proposed rule and received a lot of commentary on it, requiring DFS supervised institutions to enhance their BSA AML programs and laying out some specific and yet also unspecific requirements. So the program requires board or senior level sign-off that the program has been evaluated and is responsive to DFS's requirements. So the question of who is covered, bank and non-bank institutions that are regulated by DFS, and all of you should know who you are. what is required, risk-based, and this policy actually requires that an enterprise-wide risk assessment be conducted for every institution. So a risk-based transaction monitoring program that complies with many requirements, which again, I'm not going to go through in detail here, and a risk-based filtering program that also has many somewhat specific, although still to be kind of figured out and defined requirements. So also important for this discussion in particular, the rule requires board level or senior officer statement that having, so to speak, taken the time to become educated as to the program, educated and knowledgeable, the programs are compliant with DFS's expectations. Now there are a few important changes from the original draft of the rule. Again, for this conversation, probably most importantly, the original draft required CCO or equivalent officer to make the certification, and that's no longer true. And adds language such as reasonable and as relevant, sort of softens some of the language in the rule. It also no longer explicitly references criminal liability for a chief compliance officer or other person who inaccurately certifies to the effectiveness of the program. But the relevant criminal statutes in New York under which an individual would be prosecuted for making an inaccurate statement in a certification or something similar are still the same laws that were always in place. In other words, as far as I know, and I actually had this conversation briefly before because to me this has sort of seemed an obvious point that I haven't heard any conversation about. DFS never had the power to create a prosecutable offense through their rulemaking authority. So to the extent that the possibility of prosecution ever existed, that possibility still does exist under the laws that have always existed and by the people who are empowered to bring criminal cases, which would be a district attorney's office, the attorney general's office, or for a federal crime, obviously, a US attorney's office. And on that note.
So let me ask one question on this. And I think maybe this is an obvious and perhaps even rhetorical question, but I'm kind of interested to the response. Who will, Sharon, Polly, clients, friends, William, who are they going to get to sign this? What would you tell people about the policies, what they need to do if they're going to take on this responsibility? I'm getting a big raise for doing this, and
that's one thing I'd say.
I mean, I think first of all, I think it's really a work in progress right now, and I've been counseling some institutions on how they're going to be handling this rule, and I think that based upon the institution, it may change. Sometimes it may be the chief compliance officer. I haven't heard a lot about board resolutions, but it may be two different people. But I mean, I think sort of first and foremost, there are some really specific requirements in this rule, and I don't know that most institutions necessarily cover all of this stuff right now. So I think there's going to be work to be done to get in compliant, to get, to be in compliance with the rule. But I think it's going to be a tricky issue on who's going to be held responsible. But another question that's not addressed in the rule is, what about if you know you're not in compliance? There's a certain number of institutions in New York that are under monitorships by DFS, and there's no sort of carve out within the rule that if you know that your system is not in compliance with this rule and that it's going to be a substantial period of time until you can get there, what do? You're going to have a compliance officer or someone to be in a situation where they can't complete the certification.
And a key part of answer to your question is one of the things that the rule requires is, across business lines, that information not be siloed and that the data flow be complete. So, you have systems that need to talk to each other that don't talk to each other. And you have people who are very familiar with, for example, like the sanctions program, and someone else who's very familiar with the AML program. So how does that all come together, both in terms of, again, data flow, but also in terms of, knowledge so that you can have someone across the enterprise. Again, I emphasize that one of the things that the rule says, whoever signs off has to be knowledgeable, to some extent, still to be figured out what that is, but all of this is being determined.
I would just add, and you're going to hear me talk about my background a bit, very much a technology and operations background, and I think we've really been diving into 504 and what the requirements are. The thing that I would say is, for some of the larger banks, I don't think this is the requirements and what you have to do to get comfortable to sign off and certify. I don't think it's very much different from what you were doing to do model validation, for example. The inputs, the processing, the outputs. I think this is good practice if you want to understand what's in the black box, how the box is working, how the rules are working, how did you set your thresholds. Those are things that I think AML officers at least should be able to talk to. What I think is very different is I do think some of the mid-sized banks maybe are not there yet, and I think that's where you're going to see a lot of the gaps. And certainly the whole certification aspect and the liability aspect, that's very, very new. But I'm going to get into, when I start talking about my section, really a lot of the details on how do you look at this and how do you start putting a program together so that you start getting people and everybody in your organization, whether it's technology, whether it's business, whether it's compliance, get them comfortable, and that kind of elevate into you getting comfortable to be able to sign off on it. So we'll get into that in a little bit.
I think we're about to go to you, right? Aren't we?
Sure.
But William, did you want to add something there? You were.
The other thing I was going to say is
you were sweating. I think
whoever has to sign this, I don't see how you don't have a series of attestations below you from each individual owner of various components, from your internal audit to your compliance team, whoever, because I don't know how else you've got to build the defense to the challenge later on to say that the signature was not appropriate, and you've got to have some foundational factual record to rely on.
Sounds good. William actually doesn't have slides. I'm not sure. See if you can push past that.
But it was good that you had his
Just
name.
skip over.
We did have
It's all good.
Well, you're going to get your chance.
No. Push past that, please.
I'm trying. Can we?
There you go.
All right, so just quickly in the way of introduction, first of all, thank you, right? Thanks for the introduction, and thanks for inviting me here. Again, John Sabatini. I run a team at PwC. It's about a 300-person team, and the focus is around technology implementation for compliance officers and risk officers. And it's all in the surveillance systems, the know your customer systems, the case management systems, all the OFAC and the sanction systems. So when you think about what you need to do in understanding the requirements to implement these systems, it's a wide range of people on the team, right? It's people that have regulatory backgrounds, data scientists that are on the team, people that have done this work before, systems integration type work, very large, large data and those types of things. So that really is the background of the team. Been at PwC for about 4.5 years, as you mentioned, and then before that, I was the head of technology audit. I started off, though, in the military as an intelligence officer, where we were building surveillance systems, right? Not looking for financial crime, looking for other things, but certainly using large amounts of data and looking for red flags and things that are concerning, right? So for the better half, for about 25 years, I've been focused on surveillance systems. So that's just the background. In terms of, we covered a lot of this. I think the first couple of speakers really got into the Yates memo, the requirements, the heightened expectations, on all of that. What I want to focus on is that last bullet, the tighter focus on technology. The reason why I think this is so important is I think if you would have went back maybe 7 or 8 years ago, I think the chief compliance officers would have had a really hard time describing, maybe not William, but many of them that we worked with, right, describing how are the systems working and how do I know that these systems are effective and it's an effective program. I have complete and accurate data and it's all going into my system, and I have the right red flags so that the alerts that are being generated and handed off to my investigators are the right alerts. At the end of the day, if they're not looking at the right things, you have a lot of people and a lot of time and a lot of effort going into looking at things that maybe are not as effective as possible. I think it's with that knowledge that I think DFS took a look at this and said, we really got to get into the bowels of these systems and make sure we understand how they're working. And I think that's what this is really an effort at doing, is understanding that and not treating this like a black box anymore, but again, I'm not saying that you have to be to a point where you can implement these systems, but really describe and memorialize many of the major decisions that were made. How do I know that in this line of business I have the right coverage and I'm running all the right rules? How do I know that I have all the right data that's coming in? How do I know that I've tuned this system appropriately and the tuning of that system is generating the right alerts for the right customer segments? That's what I think that they're asking for if you really get in and dig into the DFS memo. So I'm going to talk a little bit about that in a moment. So how do we do that when we come in, and how do you get comfort that you can sign off, which is really the question that you were asking? I think the first thing is the coverage analysis that I just mentioned, going in and making sure that you're running the right scenarios. The second thing is, once you determine that I should run these 15 scenarios as an example for correspondent banking, what you would do is you got to identify those data elements to make sure that you have the right data elements to run those scenarios. So of those 15 rules, there might be 75 data elements that you have to go get. What you need to do at that point is go all the way back to the source system, make sure that you understand that the data set that you're getting is complete and accurate, and understand all the transformations and changes and reference data that's being accumulated along the way as it's being loaded into your monitoring system. Right? That is really what they're asking you to do. So when they talk about data lineage and they talk about data quality, it's not for your entire environment, it's not for your entire enterprise, it's to run the scenarios that you need to run to make sure you have an effective program in place from a surveillance standpoint. And then it's a matter of looking at the processing logic and the outputs. But that really is what I think they're being asked, what you're being asked to certify. I don't know if you have any thoughts or comments on that.
Sorry, you lost me on the last slide.
On this one?
I agree 100%. You've got to have the right people there to explain it to you in ways that 10 years ago we weren't even thinking about.
Right.
I think there's some challenges and issues with that, which I'll talk about in a moment, but I cannot disagree at all with what you've laid out. I think that's right.
Okay, great.
I actually have a comment on that as well, which is, I think one of the things to so the DFS said the reason for putting out this rule is that during its investigations, it's noticed it's noticed that these systems have not been up to par, not their words. And having worked alongside the DFS on some investigations that we did from a criminal side at the DA's office and they were doing on the regulatory side, there were many instances where I guess there was a frustration with, even microfiche systems being discovered in the basement of a bank somewhere, and suddenly, 5 years later, statute of limitations issues, you have all this new data. And there's always the question, why wasn't that together? And I think that's obviously a very sort of simplistic example and somewhat unusual, but it happens, and it's the extreme. But I think to what John is saying, this is sort of a way of saying this can't happen, and while it certainly can't happen at that extreme, it shouldn't happen on the lesser side as well. You need to look at this stuff and make it better.
Yeah, we're at a bank right now that's DFS regulated, and I actually think it had some degree of thinking, of shaping their thinking around some of this, just because the timing of all of this is several years ago. They came in, they put out a really big fine on the bank that I'm at right now, and then we educated them a lot on technology, what is an effective system, and all of that. Spent a lot of time with them. What I found in that particular instances is many of these systems were put in place like 10, 15 years ago. And when they were put in place, there wasn't the same kind of rigor that you have today. It wasn't like somebody's going in and saying, these are the red flags and the detection scenarios that I need to put in place, right? They were relying on the vendor, and the vendor was saying, for these lines of business and for these products, we're going to run these red flags, right? That's really what's happened, and we're going to set the thresholds based on our analytics, and they were really being led around, many of these companies, by the vendor. And it wasn't like the compliance officer saying, no, this is my program, this is my risk tolerance, this is my customer base, these are the rules I want to run, this is how I want to segment my population, and based on that segmentation, I'm going to set these thresholds. That was not the thinking 10 years ago. It just wasn't. So I think now that you look at that and you start challenging what's being done, I think that's been a core of what they've been asking for. All right, so next slide. So we were talking about how this might progress. So we're thinking about this a little bit like, how do you get in and get to the controls identify the controls, do proper amount of testing so that eventually it's going to kind of cascade up into the chief compliance officer or maybe the board member that we talked about before. What we're thinking is that there needs to be some kind of control level certification when you start looking at key controls, the controls that you want to make sure that you're certifying, the testing that you want done. Because remember, this has to be done on an annual basis. So you want to kind of outline how do you get comfortable, what do those controls look like, and then say how I'm going to test against those controls. A lot of what we're asking people to do first is define what you consider to be an effective program, right? That goes into what I was talking about before. You know, the coverage, how do you get the data, how do you transform it, put it into your system and make sure it's running appropriately. Just define what you think effective is. Then you have to identify your gaps, which is what you guys were just talking about, is how far away are we from there? And then the question becomes, if there's significant gaps, can you certify? And what do you do with those significant gaps, right? A lot of companies we're dealing with are saying, as long as we've identified them and we have a roadmap to fix them, you know, they can get comfortable at least certifying the program, knowing that they have to fix those issues. I don't know if that's going to be acceptable or not, but that's a lot of the dialogue that's going on right now.
Yeah, I think those are going to end up having to be conversations with DFS.
Without a doubt, without a doubt. And then the next level is the functional level, and this is where we start saying, you know, shouldn't technology have a dog in this fight? I mean, they're the ones, what if they're making a change to a front office system and it affects the data that's actually going in, you know, to your monitoring system? If there's missing data and they change that and you weren't aware of it, you know, this is a control that has to be thought about, and technology has to own some of that. You know, so does the business, and so does compliance. So I think there's going to be a functional kind of layer of this that you want to say, you know, how are you comfortable that technology and the business and compliance, they've all done their due diligence, and it wasn't just one piece of it. And then I think it gets cascaded up into the person that's going to be signing off on this. And that's just one way of thinking about it, you know, as we're starting to think about making sure that you get comfortable for that ultimate person to make that signature. And again, I don't think this is very different from what you saw with 404, right? In outlining some of those controls, what does effective look like, what is key, how do I know I'm testing it, and get comfortable that I'm going to be able to sign off on this, and ultimately the CFO sign off, you know, in that particular case. So, you know, that's kind of the comparison that I just made. Again, this is just one way of thinking about implementing, you know, this. I'm not saying it's the only way, but it's a way of sitting there saying, for 404, you had the risk assessment, you had the control documentation and framework, you had your testing, you had your certification, and then it became a continuous process. You know, here, I think the focus is really obviously going to be much more focused on AML risk, the risk assessment that you've done in your customers and your products. But then I still think there's going to be some control frameworks, and then obviously a level of testing and certification that has to be part of that. So I draw that parallel because there might be some learnings here that we might be able to use and start applying. Because again, I want one of the key takeaways to be, how do I start thinking about this and getting comfortable with owning this and being able to sign off on it? William?
All right, thank you. So at the outset, I would note, Kieran, you did seem to promise me extra drink tickets for joining the panel, and I've yet to receive them, so I trust they will come at the end. More importantly, I think it would be fun for a moment to step back and let's go away from the specifics of the requirements of attestations, et cetera, and step back to the theoretical for a moment, because that to me is really where a lot of, I think, my sort of conceptual challenges arise. We're not talking about lying, cheating, or stealing, right? Any instance of that by any compliance officer anywhere in this business, we're all banded together and say should be punished, right? And I think what the problem is that what we're starting to see, at least as we can read and understand from the enforcement matters, are situations where someone later has come through and suggested that you just were not good enough at your job. Right, and I would concede at the outset that it is virtually impossible to truly deconstruct some of these cases by reading the published opinions or the enforcement matters. And that's not a knock on the enforcement agency or the lawyers behind it. It's really, as a matter of fact, it's very hard to do. Having said that, when you work in the industry, you know what you know and you know what you read, and you begin to speculate and extrapolate into your own experience. So I think it is a significant challenge. I believe that what we're seeing today will have some results that maybe aren't the best results that we're after. Without question, and you heard it, John, from you summed it up brilliantly, we will go back to process. As a compliance officer, you're going to look at your systems and a lot differently than you would have. In other words, it's not so much the results maybe that we wanted to seek in terms of stopping financial crime, because in order to mitigate my personal risk, I'm going to make sure my process is done and done exceptionally well and triple checked. And I'm going to submit to you that over time, that may well inhibit the very innovation that makes these programs the strongest. Okay? I'll frame it another way. I think until we really come together with all stakeholders and decide what are the results that we're trying to achieve through these financial crimes compliance programs, let's get together, lay them out, prioritize them, and then develop the standards and doctrines around those prioritized results. Only then, I think, can you truly begin to assess liability for the failure to execute against those standards. Why are we here? We're here because the entire framework for anti-money laundering, which I absolutely think is an elegant theory, is we are going to dedicate our resources to the highest risks, right? We don't want you banging away on a pile of rocks when bad things are happening down the road. But that very elegance is what can make it so dangerous if you're evaluating conduct after the fact. Not understanding at the time what the standard of care was or being able to use after acquired information. I mean, if you think about it, the risks that we seek to mitigate, constantly changing, right, by design. The criminals are constantly changing it. So they're hard to understand, hard to quantify, and they're extremely susceptible, I'll get there, susceptible to the hindsight bias. And I think if you ask any compliance officer today, you know, am I doing my job? Yes. Am I doing my job ethically? You're damn right I'm doing my job ethically. What I worry about is what I don't know today that will be known tomorrow that someone will impute back into what I should have known. And it can twist your head around a little bit, but I really submit to you guys, until we get ourselves set on what it is we're trying to accomplish, we're going to be rushing to the process execution. And we're going to do it, I think, at the expense of innovation. Right? You know, basic question, how do we think we're doing overall with our doctrine? Do we think we're successful? The first question is, what is success? And until we agree on that, it's very hard to see whether or not we're going to get there. A couple other thoughts for you, too, as I looked at, I think it was the Gibraltar matter, which I thought was striking. And you know, I think it was a $2,500 fine against the compliance officer. But the words down that were killer was that this compliance officer must disclose to any future depository institution employer that this has happened. I think as a compliance officer, we worry about this. And let's face it, the mere allegation, a public allegation of somebody not measuring up and not being effective in their position is career limiting. It just is. And I think that's part of the reason why. Are we overreacting as an industry? Potentially. Sure. But when you look at that and say, wow, somebody could lob that out there, and my ability to defend it is a fact pattern that's this big and this hairy and ugly, nobody's going to listen to that. So when we take a step back and evaluate the totality of it, I really like to say that now is the time we should be focusing more on basic fundamental questions. There are too many smart people out there focusing on this doctrine to say that we still have the problems that we have, unless maybe there's something deeper going on. Maybe there is an element of what we're asking our institutions to do today that we ought to rethink or at least clarify, so we have agreement among the many stakeholders that you've heard from today, from law enforcement to regulators and to our own, of course, the businesses that we serve. So, you know, when I look at all this and I look at the new certification, I'm nervous. Sure, I'm nervous. I'm comforted by the fact that we have a lot of smart people working on it. We'll bring in the right people to get those attestations and make sure it's going. But I think we're solving for a lot of unknowns here, and that's the part of the challenge. We do what we do because we want to do it. We want to stop bad guys, especially in financial crime. But sometimes you worry, is that going to be enough if something truly catastrophic happens and we're being evaluated several years later?
Thanks, William. I'll see what I can do about those drink coupons. But I think, you know, so there's a couple things I want to say. The microphones are here and here. If you have questions, please get up out of your seat and go to the microphones. We'll answer your questions. Also, those of you who are in the virtual audience, we know there's a whole bunch of you out there. I will take your questions. They will come in on this magical pad here, and I will do what I can to answer them, or to put them in front of the group, who will then answer them. So, William, one of the things that I think that you were saying, and I want to go to our lawyers on this, is that if we look at these FINRA cases, that they come to mind. There was a JPMC case involving Madoff. That what you're talking in some of these FINRA cases and the JPMC cases, that AML policies and procedures after the fact should have identified that Bernie Madoff was a crook, or that there's I think of the very famous case, trading abuses. The compliance officer actually files SARs, but doesn't do enough or doesn't stop it, and then there's a failure in the AML program, even though it's the trading department. So, is that sort of what you're saying, that to some degree, is that a characterization of some of what you're getting at, William? First of all.
Well, it's really a broader theme to say, how far off from what is the industry standard do you have to go for individual liability to be imposed? We understand and can accept institutional liability, but do we have the precision in the requirements that existed at the time to be able to judge that gap, to then be able to assess liability against an individual for failing to do a better job? That's really my point.
Any comments in terms of the cases? Was that an unfair characterization of the cases, or?
No, I think it's a fair characterization. I mean, what you're seeing right now is that there's a real focus, or what I've been seeing since I've been in private practice is there's a lot of focus on failure to file SARs. Essentially, there's two components to the Bank Secrecy Act, and to a certain extent, what William's saying is it is hitting exactly upon this problem. There's two twin aims of the Bank Secrecy Act. It's to have an effective, for a financial institution, to have an effective anti-money laundering program, which means keep the bad actors out of your institution, keep them out of the US, and then the other aim is to file suspicious activity reports. By the very nature, you need some bad actors that you can report on. I ran a SAR program when I was in SDNY, reviewing SARs. I know Polly looked at the same when she was at the DA's office. That's the lifeblood of law enforcement. What financial institutions do in filing SARs is critical to the mission of law enforcement. It helps to develop cases, it helps to support cases. So you don't really want that to stop, but what we're seeing now in terms of the decision to file a SAR is a complicated one, and it's based upon a bit of information at that time. Even if you have the perfect system that alerts on that, someone is going to look at it and make a subjective judgment. Is this activity actually suspicious that justifies filing a SAR? But what you're seeing is the decision not to file one is a very, very dangerous one. The JPMC case, it was with Madoff, it was the failure to file one SAR that had obviously substantial significance. But you're seeing them sort of across the board. Even though every regulator will say, we don't second guess SAR decisions, that's not what we are, by the very nature, going back and looking at whether or not a SAR was filed is, to a certain extent, second guessing it. And it's like reading the end of a mystery. If you read the end, you know how it ends. You, of course, as you go back and read the book, if you read that first, you go back and read the book, of course you see all these clues along the way. Once you know that a crime has been committed, it's very easy to go back and look, even in the best faith possible, to see things that were amiss. So I think that there is a real issue in terms of regulators and prosecutors sort of looking back at that with some kind of, somewhat of a taint because a crime has occurred. The funny thing about the sort of sad thing about individual liability is I came from a place of being a prosecutor where people committed crimes, federal crimes, you committed it to make money. You got money and that was why you did it. For this, essentially an AML failure, an AML officer isn't getting any money, extra money for doing this. They get no benefit for missing this or not having a good program or having a deficiency. They simply made a mistake. They very rarely are actually, there's an intent not to do a good job. It may be that they thought they were, but in hindsight, they could have done things differently. And I think that's the real danger in this space is that to impose liability on individuals, and they're not the CEO of the company. You're holding responsible for the most part, oftentimes, more mid-level people that are making these mistakes, particularly at a smaller institution.
Anything to add?
Yeah, I would say one of the kind of interesting things about regulated institutions or regulated businesses is that you get into this almost weird gray area where you semi-criminalize civil wrongs so that almost every criminal violation, there are some exceptions, but not a lot, require an intentional bad act. In other words, you don't have to necessarily, I intend to violate this statute, but you intend to do a bad thing. Bad is obviously a pretty loose word, so loosely speaking. Negligence, on the other hand, is where you just, as William said, as Sharon said, you make a mistake, and it can be a really big mistake, and it can be multiple mistakes. And one of the questions here is, what do you want the consequences for individuals of really bad mistakes to be? And maybe, maybe that person should be fired because the person's really bad at their job. If you get so prescriptive that, again, going back to what William said, you lose the ability to be a creative thinker as a compliance officer, that's a huge loss. And I think that's the balancing act that is maybe not always properly balanced.
We have a question in the audience.
Yes, thank you. So a BSA officer cannot come to terms with the key decision maker, whether it's the board of directors, the president of the bank, the chief risk officer, regarding risk tolerance. And there is something wrong in the BSA officer's eyes with the program. BSA officer leaves the institution. How does that BSA officer protect themselves, especially when some of those conversations, those key conversations, happened by a conversation orally or verbally and not in writing, and they're no longer at the institution, they don't have access to the documents that said, I think there's a problem. And how many years back will the regulators go for the BSA officer? Like, are we responsible forever?
I mean, it can go back very, very far. I think that's a real risk. I mean, I was on another panel earlier today, and someone said something that I thought was quite brilliant or apt, is that if you don't document it, it didn't happen. And that's what you see, is you see investigations that 5 years ago, I mean, I'm representing an institution now where the regulators, a whole slew of regulators, are looking at things that happened 5, 6 years ago. And there's no one there that remembers it, et cetera. But I think that to the extent possible within the records of the institution, you've got to document it. Concerns that you have to document,
Wouldn't it be in the bank's interest to lose those documents and the BSA officer has no access to them?
I mean, let's just put it this way. I think that there is a situation, there's the sort of opposite of the Yates. I mean, there's a whistleblower context where, if there really is that type of conduct where they're absolutely hiding that, it's rising to a different level.
That's where you get intentional.
That's where you get.
What if you're under a non-disclose?
Well, but I think maybe one way to think about it is non-disclosure can't non-disclose illegal activity or whatever, but here's how I would think about it slightly differently. And I think one of the unfortunate results of where we are today versus 10 years ago is, as a compliance officer, I am documenting a lot more than I ever did, right? Because I understand as I get older, my memory isn't as strong, but I also want to make sure it's clear what came across our desk at the time, right? What did we see? What did we think? What did we do? The hypothetical you pose that I've made the escalation, right? And yeah, I guess theoretically an institution could tear it up and destroy records, but let's assume that's not going to happen because that's a whole different level of malicious something, right? But what I would suggest to you is if you're in that situation, you've made your escalation, you've gone as you are supposed to, as we're charged to go to your boss, you go up to the board, ultimately to the board of directors, and failing to get satisfaction, you say, I'm sorry, I can't stay, right? And then you make the resignation. My guess is that's a pretty good record for you later on to the extent the investigations come because you have documented, you put it through a formal process. And I do think, though, that the broader point to be made is that, yeah, I document a heck of a lot more than I used to. Not because I think everything's going to be questioned, but I think it's just in this day and age, it's better to have it documented than not.
So you document it, but you're no longer at the financial institution. You don't have access to the documents.
Correct.
How does that help you? How does that protect you?
Because they'll be in the records. Again, respectfully, if that's an institution that's going to be shredding documents and destroying electronic records to avoid it, we're in a different world anyway. My guess is most regulated institutions that wouldn't happen. I hope.
Thanks.
Yeah, I mean, the other situation is, your situation, but not taking it that extra step farther, which is that they're really...
Hypothetical situation.
Pardon?
Hypothetical.
That
And what was your name again?
hypothetical. Yes, that hypothetical situation. But, I mean, there are often situations where their minds differ on what risk the institution wants to be exposed to, and you know, decisions made in terms of how to handle, you know, certain transactions. For those things, I do think it is critical that it be documented. It should be to regulators a good thing that there is debate on it, and that a decision is made, and that there is a process. If you look back at some of the cases, particularly some of the FINRA cases, what you saw is that there was no written policy, there was no written guidance, there was no procedure if there is a dispute and how it gets elevated. So a lot of times, the best defense is for an institution, and also for an individual that's running the compliance program, is to actually have written policies and procedures that take into account all of the different things. That in the end, and then you of course have to, in the end, hope that the proper records are saved, et cetera.
Okay, thanks.
So maybe, I think we've probably depressed everyone here and how tough things have gotten. Can we talk a minute, and this may be also where we might come back to this a little bit at the end. Everybody, like, you know, what am I doing differently now as a compliance officer than I did 5 years ago? Am I consulting a lawyer? Am I finding out about liability insurance, which I don't know that, okay, so let's talk about some of the things that people should be doing under this new personal liability regime.
Well, I think that there's a much greater expectation that a compliance officer not just have the right systems and processes in place, but that the person that's overseeing the compliance program, particularly the AML function, that they know the business, that they actually know the business, that they coordinate, they understand. And one of the problems in the Raymond James case is the business changed over time, but the AML program didn't change with it. So I think it's important now is to really to have an appreciation that businesses aren't static, things change, and risk change. Criminals are very, very clever, and they come up with all different ways to, you know, sort of get around the systems that are in place. So I think that an AML compliance officer has to really understand the business, has to understand the risk, has to understand the regulatory environment. And the other thing that I saw over and over again in cases that I worked on with the government is siloing. That what the business lines don't really, you know, coordinate with compliance or legal, and that they're left with sort of everybody doesn't know what everybody else is doing, and that's just something that can't happen anymore. That's really got to change. There's got to be much more of an integration within the institution to make sure that, you know, there's real coordination in terms of understanding what the risk is and how it's being handled.
Yeah, I would. Two kind of follow-up points on that. One is the DFS rule. One of the consistent messages throughout is ongoing, ongoing, ongoing. Remeasure, you know, reassess, re-audit. So I think that that point is absolutely true. And in that particular piece of regulation, I also sort of as an anecdote to kind of also support what Sharon just said, we were consulted on something where there was a whistleblower complaint it was an employment case. And this person said that they were being retaliated against for making a complaint in the compliance space. So the employment lawyer wanted us to assess the validity of the whistleblower's complaint about what was happening in the AML department. And we went in and looked at that, and what we saw was no problem in AML, but the issue that had come up was a sanctions issue, and there was no communication whatsoever between the two. So somehow, you know, the sanctions issue would come to AML, AML had it, or I guess as they were doing an AML review, they discovered that there was a sanctions issue, but they weren't thinking sanctions, never reported it, and months went by, and months went by, and they continued to bank this sanctioned. So that to me was very eye-opening in terms of really realizing how extremely siloed it can be.
Yeah, I mean, the thing that I would add is just challenging the status quo. I think that a feeling that, at least when I get when I go in, where maybe there's not enough discussion around why was something put in place, why did you make decisions about putting, again, a scenario in place rather than maybe KYC controls, or maybe there's a report that you can be leveraging. It's not all about technology, right? I know I talked a lot about that, but I think it's more understanding why. Like a basic thing, I mean, I work with a lot of chief compliance officers or AML officers that come in place, and their first question is, where do I need to spend my time and my focus? And they want to look at all the transactional activity, the customers, look at unique customers. They really want to dive in. And then when they start seeing that I'm running all these scenarios against a population of customers that I can just, by knowing their activity better, by knowing their customers, by putting front-end controls in, I don't have to put all these detection scenarios in. Having that kind of analysis being done, I think really needs to happen a lot more. And then understanding why things were put in place, and then being able to really challenge that.
So we're talking a lot about, and William, you mentioned this, documenting everything you do. Are there other things that you're doing differently than you did 5 years ago?
Sure. I mean, you tend to think about situations as they're arising. I'm convinced most major enforcement actions and individual liability don't come from the pivotal case that gets escalated up, right? Because there's enough of process around it. But you really do start asking the question of, am I paying enough attention to the 20 things that came across my email this last hour? Or is the one thing that was the 17th thing through there going to be the one that pops up? I do think about that. I become increasingly concerned with what peers are doing. Because the doctrine tends to be driven by what people are seeing, and the best practice becomes sort of the expectation, and that's the nature of the risk-based approach and sort of the reasonable programs that we have to put in place. I will spend more time and money today trying to figure out what everybody else is doing to make sure that I haven't missed something. And that means bringing in folks like John and others and say, what are you seeing? What are you doing? Helping me think about it. That is a change, right? It just is. And at the end of the day, I think the cultural component that we talk so much about has different meaning when you think about what it could mean when something pops and goes badly, right? How deep does it go? How much are people watching who should be watching what might be taking place that aren't necessarily part of compliance? I think I've thought a lot more about that lately, and to say, do we have the right ability to get that information back to the program to make sure we know what they know if they're willing to raise their hand?
And I mentioned directors and officers liability and these kinds of things, but this is really limited. Is any of that stuff worth anything if a compliance officer is having trouble with the regulator or in front of arbitration with FINRA, or what do you tell people?
I mean, it certainly can help, and you should understand, you should absolutely look into. I mean, part of it is you've got to understand what your institution's sort of policies are in terms of, will they provide indemnification? Are they going to pay for attorney's fees? I mean, there's a whole bunch of things. I mean, particularly for institutions of all different sizes, in terms of understanding that. And then in terms of directors and officers coverage, what it's going to cover. There very well may be situations where this conduct or these allegations will be carved out. So I think you need to really look carefully at what your company's policies are in terms of that, because if there is an investigation, sort of going back to what Polly was talking about in the Yates memo, there is a certain aspect to the Yates memo that pits the government, pits the corporation against the individual. And I think that more and more, one of the sort of consequences of that is you're starting to see individuals getting separate counsel. And so typically the institution will pay for it, but depending upon where you were, they may not. And so, you sort of have to understand what your company does, what they will do under these circumstances. But it may be that the insurance is going to be appropriate because, among other things, not just the liability, but to hire outside counsel.
And any thoughts about, some of these situations, you see the cases where you do have a compliance officer protesting. I suppose there's no line, but when do you have to go public or quit or whatever? William, you're smiling.
I get it, and I'm sure in the most egregious cases it's a very easy thing. My overall concern with that is that's awesome to say, except it's never going to be that obvious at the time. And, you know, a compliance officer has a family, they've got a mortgage, and it's easy to pound your fist and say, you should have resigned. You know, in an obvious case, there's no question, right? The hypothetical over here, I think that was, yeah, okay, I'm walking. I think the unfortunate thing is in a lot of these cases, it's not going to seem that egregious except later on when after acquired information is fueled back into it. That is a very tough thing for me as a compliance officer. I get it. I understand it intellectually. I think as a practical matter, it's hard to apply.
So as we look forward, we're almost out of time, but as you look forward to, I want to ask about the Hader case and if there's things that we should look for in decisions or what, I mean, how precedential is that in terms of compliance officers everywhere, or do we think that that's kind of a unique case? I'm aware of the fact there's another MSB that lately that has similar and seemingly perhaps even more massive charges. And right now there's individuals named. I don't know whether other people or who will be named ultimately. But so what does that case mean for compliance officers?
Well, I mean, I think that in the circumstance where there really are egregious violations, I think that you are going to see that FinCEN will be assessing penalties and against individual compliance officers and, you know, bringing that action to the Department of Justice. But it's not something that's done lightly. I mean, the thing about the Hader case is, and it kind of gets, the facts kind of get lost, but it was a pretty egregious circumstance. Among other things, Mr. Hader was not a low-level employee of MoneyGram. He was the chief compliance officer over two parts of MoneyGram, the AML and the fraud. And here, MoneyGram entered into a deferred prosecution for aiding and abetting wire fraud. I mean, what was going on there is that that agents that had various different businesses were participating in a fraud and laundering the money, and there was warning after warning after warning given, and the allegations are that Mr. Hader did nothing. He sort of walked away, looked the other way, and allowed it to go forward to the financial advantage of MoneyGram and the agents. So I think it's a different case than the kind of cases that you're seeing. This isn't a negligence one, at least as alleged. We haven't heard Mr. Hader's side of the story. It could be a very, very different picture. But based upon the allegations that are allowed to go forward, it looks like a pretty egregious case that you're just not going to see a lot of.
We're almost out of time. Does everybody have a takeaway?
Oh, I forgot.
You had a double take, I think. That wasn't a takeaway. That was sort of a...
No, I think, look, we don't want to lose our minds about this. There are a handful of cases, right? But I think as compliance professionals, it's in our interest to understand what exactly are they driving at in the circumstances that they're making these claims as best we can understand them, and then asking that question, what else do I need to know? And again, I looked at your roadmap, John, was really good in that respect. What else do I need to know about the functioning of this program to get myself to the point where I can say with more certainty that I think things are happening the way they ought to happen?
I would say, I mean, I liked what William said before about about benchmarking, right? I do think it's important for you to sit there and say, how do I compare against my peers? And if we're talking about not something that's not egregious and it's more negligence, how do I know I'm keeping up? I'm not falling behind the curve. I think that's a big piece that you got to think about. And then, like I said, really have a better understanding. These, again, I said it before. These alerts are not just being generated by magic, right? There's something that's generating those alerts, and it's causing you to spend millions and millions of dollars to investigate them, know where they're coming from, and how they're being generated. I think that's important.
Yeah, so I sort of want to steal what everybody has said. One thing, I'll echo Sharon on document your decision making, even if it's almost conversational decision making. Look carefully at these rules because they all come from somewhere. You know, the new policies are responsive to something, and you can speculate, and that can be dangerous, but they also reflect specific things, I believe, that regulators or the government, prosecutors are seeing as they look inside, because again, these agreements, like the DPAs, which try to have as many facts as they can, are a very, very small part of every story. So try to think about what's motivating these rules and animate them as much as you can.
I agree with everything. I would just add one other thing. It's very important as a chief compliance officer to have clear policies and procedures, written policies and procedures, and to follow them. You can't believe the number of cases where institutions get in trouble and individuals because they have great policies, but they actually don't really follow them. So I think that is, sort of my one takeaway is put it all down in writing and comply with it.
Thank you so much to the panel. There's going to be a special presentation that will begin in here in 10 minutes or less. So you don't have to go far. Don't go far. I think the special presentation is going to be pretty interesting, and I would encourage you all to stay, and I know there'll be people returning. In the meantime, can you join me in thanking our panel, Sharon, Polly, John, and William.